Hi guys, this is the lecture video for chapter 10 for remedies of parties. So we will be discussing what are the remedies available to the seller and the buyer in cases of breach of the contract of sale. So the content of this discussion will be as shown in the slide. We will discuss first remedies available when there is a sale of a movable and remedies when there is a sale of an immovable, because there are different remedies, guys. When there is a sale of a movable or a personal property, then the ordinary remedies of the seller for non-payment of the price will be rescission. And in sale of goods, we have Article 1595, wherein if the ownership is already transferred to the buyer by delivery of the subject matter, then there can also be an action filed by the seller for the price, which is specific performance. If there is no transfer yet of ownership, and if, for example, the goods cannot be readily resold, then the seller can also opt to hold the goods as bailee for the buyer and thereafter file an action for specific performance to demand payment of the price. If, for example, in their contract, the price is made payable on a certain day, regardless of transfer of ownership, so regardless of whether there is actual delivery or not, then the seller here can proceed with filing an action for specific performance to demand the price. So those are the ordinary remedies of the seller if there is non-payment of the price. That's Article 1595. And we also have special remedies for the unpaid seller. And unpaid seller here, guys, it's very technical. If we take a look at the article shown in the slide, Article 1525, then there is a definition of an unpaid seller. Dili lang siya maskikinsa na unpaid seller. So who is this unpaid seller who has special remedies under the Civil Code? So first, the seller is considered an unpaid seller when the whole of the price has not been paid or tendered, when a bill of exchange or other negotiable instrument has been received as conditional payment, and the condition for which it was received was broken by reason of dishonor of the negotiable instrument, the insolvency of the buyer, or for any other reason. And second is that the goods, subject matter of the sale, is still in the possession of the seller. So very important siya, guys. Dapat naa pa siya sa possession sa seller ang kaning goods. So the unpaid seller can be, of course, the seller himself or herself, the agent of the seller to whom the bill of lading has been endorsed, consignee or agent who has himself or herself paid or is directly responsible for the price, and any other person in the position of the seller. So what are the rights of this unpaid seller? So there are four major rights. First, there is the possessory lien. Then we have the right of stoppage in transito. We have the special right of resale and the special right to rescind. So why is it special, guys? It's special na remedies because dili siya ordinary remedies. because this can be exercised by an unpaid seller who still has possession of the goods. So it is essential in possessory lien, guys, to exercise this right, that the seller still has possession over all or some of the goods. So when do we consider the possessory lien lost? If there is delivery and there was no reservation on the transfer of ownership or the right to possession. When the buyer or an agent of the buyer lawfully obtains possession of the goods, and if there is waiver of this possessory lien. And take note that this possessory lien is not affected by any act or disposition made by the buyer. And the only exception to this is when the seller will consent to the disposition, meaning to the disposal of the goods. And second exception, when possessory lien, when the buyer's action can affect this possessory lien, is when a negotiable document of title is negotiated to a purchaser for value and in good faith. So since possession is crucial, guys, if there is only a part of the goods remain in possession with the seller, then there is only a lien on the remainder of the goods. So how do we exercise this possessory lien? What are the requisites? First, you can exercise this possessory lien when goods have been sold without any stipulation as to credit. When goods are sold on credit, but the term of credit has expired. And third, when the buyer has become insolvent. So, sale of goods and wala sila nagsabot as to credit, or when the credit has already expired. So what is this possessory lien? So regardless of whether or not ownership has passed, it is simply the right to retain. Remember that the buyer, if there is a time fix for delivery of the subject matter, then the buyer can actually compel the seller to deliver. But this special remedy of possessory lien will entitle the seller to retain the goods. And in the instance when ownership has already passed to the buyer, even without delivery, okay, remember, the seller and the buyer can stipulate that even if the seller still has not delivered the subject matter, then considered na as transferred ng ownership. That can be one stipulation by the parties. So when ownership has not yet passed, it is the right to retain. In addition, there is also a right to withhold delivery, coextensive with the lien. So in these cases, guys, the seller will not be liable for any delay or for his refusal to perform his obligation to deliver the subject matter. How about stoppage in transitu? What is this right of stoppage in transitu? When is the right of stoppage available? When is the buyer considered as insolvent? When are goods deemed in transit? And when are goods no longer deemed in transit? And how is the right of stoppage exercised? To answer. Let's find out in my notes. So stoppage in transitu, it is the right of the seller to reassume possession at any time while the goods are in transit. So, si seller ani guys, ni part ways na siya. But, by virtue of this special remedy, then the seller can reacquire possession. Let me just fix my slide, okay? Right, so the right of stoppage in transitu, it is the right of the seller to reassume possession at any time while the goods are still in transit, provided that the buyer has in the meantime become insolvent. So the seller here must have knowledge na si buyer di na makabayad. So considering that di na jud siya mabayaran, then this special remedy entitles the seller to retake possession of the goods that he has already delivered or parted with. So when is this right of stoppage available? Of course, katong ganina possessory lien, essential na naa pa siya possession. In this case, this special remedy of stoppage in transitu, it means it presupposes that the seller has already parted with possession and the buyer has already become insolvent. So when do we know that a buyer is insolvent? When do we consider the buyer insolvent? So when a buyer is deemed insolvent, when he or she has either ceased to pay his debts in the ordinary course of business or cannot pay his debts as they become due, whether or not there were insolvency proceedings commenced against the buyer. So when do we consider the goods as already being in transit? So it is considered as in transit if it is delivered to a carrier by land, water, or air, or delivered to a bailee. And such delivery was for the purpose of transmitting the goods to the buyer or to the agent or representative of the buyer. So the goods are also considered as in transit if they have been rejected by the buyer and the carrier or other bailee continues in possession of the goods, even if the seller has refused to receive it back. And goods are considered as no longer in transit if the buyer has already taken delivery of the goods before its arrival to the appointed destination. So meaning na hijack ni buyer, guys. Very important shipment. Even before ni arrive sa port, gisugat ni buyer kay ganahan jud siya na makuha ang goods. Even if insolvent na siya, wa siya kabayad. So after the arrival of the goods at the appointed destination, the carrier or the bailee acknowledges to the buyer that the goods are being held on the buyer's behalf and continues in possession of them as bailee for the buyer or the agent. So considered as in no longer in transit gihapon maski wala pa ni buyer ang actual possession. It is still with the bailee or with the carrier. But the carrier or bailee recognizes already that this good is owned by the buyer is already on account or for the account of the buyer. And goods are no longer in transit if the carrier or other bailee will wrongfully refuse to deliver the goods to the buyer or the agent of the buyer. So third instance, when no longer in transit siya guys, if there is wrongful refusal to deliver by the carrier or bailee. So how do you exercise the right of stoppage in transit 2? So first, the seller must reobtain actual possession of the goods, or the seller can simply give notice of his claim to the carrier or bailee. So that's the right of stoppage in transit 2. Another special remedy to the unpaid seller for the unpaid seller is the special right to resell goods and to rescind the sale. So two different rights ni sila guys. I just compared it, made a comparison of them in this table. So in resale guys, take note that there was previous exercise of possessory lien or stoppage in transit 2. And since the seller here is still in possession or was able to retrieve possession by stopping the goods in transit, then the seller here can resell those goods. Why man makaresell siya? Take note that the goods are perishable in nature in order to exercise this special right of resale. And this right to resale is expressly reserved upon default. So it is provided in their contract that if there is default, then there is express grant of the right to resale in the contract. And the buyer must be considered in default or has already defaulted for an unreasonable amount of time. So what happens here when there is a resale of the perishable goods? Then the seller is not considered as liable anymore to the original buyer, katong ni default na buyer. But if, for example, despite the resale of the goods kay nalugi si seller, the original buyer can be made liable for the losses. So notice to the original buyer is not required. Okay. And the sale here can be public or private. And the seller is prohibited from buying the goods. So dapat na adyoy new buyer. The seller cannot buy it for himself or herself. Okay, and the fourth special remedy of the unpaid seller is the special right to rescind. So there was previous exercise of possessory lien or stoppage in transit 2 as well when you exercise this right. And also there must be an express stipulation in their contract on the right to resell. And the buyer is also in default for an unreasonable amount of time. So this right to rescind, guys, this can be used when the goods are not of perishable nature. So the seller here can afford time to rescind the sale before selling it to a new buyer. And the buyer here is also made liable for losses. So since there is an act of rescission, guys, notice is required. Okay? It is ideal to give notice because you are rescinding the contract man. And if walay formal notice, there must be some overt act to signify the intent to rescind. Right? So those are the remedies of the seller those were the remedies of the seller. We discussed the ordinary remedies and the special remedies of the seller. How about the remedies of the buyer when there is a sale of movables? So si buyer here, since we are talking about the remedies available to the buyer, then it presupposes that there is a breach of contract or non-performance by the seller of the obligation to deliver or the obligation to transfer ownership. So there is a breach of warranties of the seller. So remedies of the buyer when there is failure to deliver the subject matter, which in this case are goods or movables or personal property, then there can be an action for specific performance to compel delivery. And this is found in Article 1598. If there is a breach of warranty, then the buyer here are given options. The buyer can either accept the goods, then recoup the price. By recouping the price, meaning offset siya, he will only pay the price in accordance with na i-offset to whatever loss that the buyer suffered due to the breach of warranty. The buyer can also accept the goods but still file an action for damages. The buyer can refuse the goods and file an action for damages. The buyer can also rescind, refuse to accept, or return the goods and then recover the price if the buyer has already paid. So take note that these remedies of the buyer are alternative except for rescission. There is also this situation, guys, when the buyer, when it becomes manifest that the seller can no longer perform the obligations that was assumed, the obligation to deliver or to make good on the warranty, then the buyer here can suspend payment if there are payments to be made in installment. So makasuspend og payment si buyer. And this right to suspend the payment, counter lang siya ni seller by giving security for the price and if there is a stipulation to the contrary in their agreement, in the contract of sale. So meaning, para padayon og bayad si buyer, mag-put up og security si seller. So that in the event na di na gyud maka-deliver si seller, then the buyer can recover the price that was paid. Right? And in cases of movables, guys, this particular remedy, the recto law remedies, is very, very important. Why it's so important? Okay, very popular siya nga topic sa mga previous bar exams. Makatubag jud tag usa ka recto law at least ba? I'm not certain sa recent na bar. Is it still the case? So recto law remedies, this applies to sale of personal property payable in installment. And also, it applies to lease of personal property with option to buy. So in jurisprudence, guys, in particular, this PCI Leasing and Finance Incorporated versus Giraffe X Creative Imaging. This recto law remedies also applies to other financing transactions derived from sale of movables in installment. So when is there a sale on installment? This is answered in the case of Levy Hermanos versus Gervasio. So I hope you read this case. But in this one, we will know when a sale is considered as a sale on installment. So on March 10, 1937, the plaintiff Levy Hermano sold to defendant Lazaro Blas Gervasio a Packard car. Defendant Gervasio, after making initial payments, executed a promissory note for the balance of 2,400 payable on or before June 15, 1937 with interest at 12% per annum. And to secure the payment of the promissory note, Gervasio mortgaged the car to Levy Hermanos. The defendant, Gervasio, failed to pay the note upon its maturity. So Levy Hermanos foreclosed on the mortgage and the car was sold at public auction. And it was Levy Hermanos who was the highest bidder. And the price that the car fetched at the public auction was 1,800 pesos. So naapay balance. Levy Hermanos thus filed an action to collect the balance of 1,600 and interest. So that's why the present case. So one of the issues that had to be resolved is whether or not the recto law can be made to apply to bar the action for collection of the balance. So in resolving the case, the court had to describe or define what a sale on installment is. So the court here said that the contract in the instant case, while it involves sale of personal property, it is not one on installment, but on straight term, in which the balance after payment of the initial sum should be paid in its totality at the time specified in the promissory note. So principle here is that the provisions of the recto law cannot apply to a sale where there is an initial payment and balance payable in the future, because this is considered as a straight sale. The seller here can recover the unpaid balance of the purchase price against the buyer, even when the latter already lost, even when the buyer already lost the thing he bought due to foreclosure of the mortgage. So, klaro na taon sa ang installment. Dili siya ka ng 2 gibbs. Dapat na more than 2 gibbs, no? So, the recto law, guys, this is Article 1484 of the Law on Sales. So, it gives the remedies of the unpaid seller of personal property payable in installments. And there are 3 remedies for this unpaid seller. First is to exact fulfillment should the vendee fail to pay any installment. Second, to cancel the sale should there be 2 or more unpaid installments. And third, foreclose the chattel mortgage should 2 or more installments be unpaid. So it's exact fulfillment, cancel the sale, and foreclose the mortgage. Article 1484 further provides that the seller shall have no further action against the purchaser to recover any unpaid balance of the price. Any agreement to the contrary shall be void. So what's the significance of this prohibition, guys? So are these remedies alternative or cumulative? What do you think? So Article 1484 are alternative remedies. It means that the exercise of any one of those remedy would bar the exercise of the two other remedies. And this prohibition, guys, from the seller to for this prohibition upon the seller from availing of further remedies after he has chosen one specific remedy is founded on the principle that no one shall enrich himself at the expense of another. So when the unpaid seller has already enforced the contract by way of collecting the amount due, the seller can no longer rescind or cancel the contract. He cannot also foreclose the mortgage over the thing. For the exercise of one in full forecloses the right to exercise other remedies. So recto law remedies are alternative remedies. So that's why we need to know when a specific remedy is already barred by the exercise of one remedy. So I made this analytical tool to guide us. Okay, there are lots of cases wherein we're not certain if the action taken by the unpaid seller is already barred. Okay, nakabuhat na siya, naka-avail na siya o lain na remedy. So there are two levels of barring effects kaning si recto law. First level is with respect to the choice of remedies. So once the seller has made a choice on what remedy to avail of, then the barring effect takes place already. Barred the moment the seller has chosen his or her preferred remedy. Second level is non-recovery of unpaid balance in cases of rescission and foreclosure. So if there is rescission of contract and there is foreclosure of the mortgage, if there are any unpaid balance pa, then such is already barred, and it is barred at the very moment of foreclosure and actual sale at public auction. So when is the seller deemed to have chosen a remedy? As to specific performance, it is deemed chosen when the actual case is filed in court. Okay, not just at the time of the sending of the demand letter. So case in court gid siya. Foreclosure is deemed as the chosen remedy at the time of actual sale at public auction. So prior to that time, guys, prior to the actual sale at public auction, the seller can still receive payments from the buyer, and the seller is not obliged to refund the payments made. Also, prior to that actual sale at public auction, the seller can desist from foreclosing on the chattel mortgage and can still sue on the unpaid account. So what is the extent of the barring effect on recovery of the unpaid balance when there has already been foreclosure on the mortgage? First is that the seller is barred from recovery of the balance from additional securities put up by the buyer or a third person. So if the mortgage, if the debt is secured by other securities, by additional securities other than the chattel that was foreclosed, then dili maka-foreclose na si seller on those other securities. So both judicial and extrajudicial proceedings to exact recovery of the unpaid balance are barred. So by unpaid balance, guys, what we mean is that the interest imposed on the principal amount owed, attorney's fees, expenses of collection, and the cost. The only exception to this is that attorney's fees can be recovered. Attorney's fees can be recovered if the buyer who did not pay, did not proceed with the purchase, will hide the chattel from the mortgagor, and the buyer mortgagor will unjustifiably refuse to surrender the chattel. Kay in the chattel mortgage law, guys, you're not supposed to hide the chattel. You're supposed to inform the mortgagee if you are transferring the location of the chattel that was mortgaged. So if there is unjustifiable refusal to surrender the chattel, then attorney's fees can be recovered. Kay need man ka ma-file ana og rep levin to recover the chattel. So that's the time when there can be recovery of attorney's fees. So pasalamat ta sa Supreme Court kay sigurado nila ba na makasingil pa ta attorney's fees kung mag-file og rep levin. So how do we know that is there a barring effect when the chosen remedy is rescission? So rescission seeks to cancel the contract and to waive any further claim on the purchase price, while foreclosure seeks to pursue and realize on the purchase price of the sale. So when the seller takes possession of the property in rescission of sale, because in rescission, guys, remember that there is restitution. I-return nila to each other whatever was received from the contract. So when the seller here will take possession, recover possession of the personal property, then the seller is already barred from recovering the balance of the price. Kaya dapat ibalik gani unta ng price. So the barring effect is implicit from the nature of the remedy of rescission, which requires mutual restitution. Barred na. Kaya nag-restitute na guys sila. Gusto pa man niyang i-recover na unpaid balance. So question, attorney, what can we do if the recto law bars recovery of the unpaid balance? So what can we do for our clients na wa sila nabayaran, yan nagamit na ang personal property, like for example sakyanan, usual ani mga sakyanan. So what other remedy does the seller have that do not produce barring effects? So this is an actual case, guys. The seller can actually file a civil action for recovery of the unpaid balance. Then, as provisional remedy, mag-preliminary attachment of the mortgage subject matter. And this preliminary attachment is not the same as foreclosure. So, gi-attach na nimo, meaning, ato na i-store sa storage place sa court. Si court mo take og custody of the personal property. And there can also be an action for replevin. So you are just recovering possession of the chattel that was mortgaged. So if those are the actions filed in court and availed of by the seller, then we do not apply the recto law. right? And the application of the recto law extends to leases with option to purchase. And in this PCI Leasing and Finance Incorporated versus Giraffe X case, recto law applies even if it is not expressly provided for in the contract ang kaning option to buy. Kay financial lease money ang contract sa case. And there was it was silent, the stipulation on the option to purchase was read by the court as a sign to apply recto law. Okay, it is provided for in the law on sales na the recto law article 1494 applies to leases with option to buy. Because in financial lease agreement, guys, the lessor or the owner of the thing being leased will usually stipulate that they have the right to take back possession if there is non-payment of the rental. And taking back possession of the leased movable amounts to foreclosure. So that's why the recto law is made applicable in financial lease agreements. So the remedy of the lessor is just to rescind the contract. Okay? Dili allowed ni siyang recovery of possession. Okay? It amounts to foreclosure without first rescinding the contract. So question. A bought from X company a truck payable in monthly installments. As security for the payment of the balance of the purchase price, he constituted a chattel mortgage on the truck in favor of the company. Because of failure to pay 3 consecutive monthly installments, the company filed a complaint to recover the unpaid balance. A writ of attachment was subsequently issued against the properties of A. Thereafter, the truck was sold at public auction, in which the company was the only bidder for 1,000 pesos. But there was still a deficiency of 1,000 pesos. The court condemned A to pay the company the deficiency plus interest. Is this order of the court in accordance with law? Do you think, guys? And the answer is not shown in the next slide. Okay, let me fix my slide first. Okay, so what's the answer to this question? Is the order of the court in accordance with law? So the answer, guys, is yes. The company had chosen the first remedy, which is exact fulfillment or specific performance. So if the seller was able to get a favorable judgment from the court, and therefore there is an execution of that judgment, then the properties attached will be executed to satisfy the judgment. And those attached properties will be sold at public auction. So, since the judgment awarded by the court is for the entire amount owed, then masatisfy gyud ang judgment sa court. And there's no application of the barring effect of the recto law. It is only enforcement of the execution of the judgment. Para mo nalibog. So C, purchased by installment from X company a diesel truck for 45,000 pesos. To secure the payment of the price, he executed chattel mortgage over the vehicle in favor of the company. As additional security, R, friend of C, executed a real estate mortgage. So, na chattel mortgage over the truck. And then his friend also executed a real estate mortgage on a property that was owned by that friend. Subsequently, X company, the seller here, by means of a discounting transaction, assigned all of its rights in the two mortgages to FIF company, with due notice of the assignment to both C and R. So C here failed to pay any of the installments. So the assignee, fifth company, extrajudicially foreclosed the chattel mortgage. At the foreclosure sale, FIF company was the highest bidder and bought the truck for 15,000 pesos. CNR then filed an action to cancel the real estate mortgage. They invoke Directo law in order to avoid foreclosure of the real estate mortgage. Ipa-cancel na nila ang REM. So may fifth company foreclose on the real estate mortgage in order to recover the deficiency. So answer, guys. Article 1484 is applicable. This is clear and simple. Clear and simple ba? Why is it made applicable? The buyer failed or defaulted in the payment of two or more of the agreed installments, and the vendor can exact fulfillment of the obligation or cancel the sale or foreclose. So these remedies are alternative, not cumulative, so that the exercise of one would bar the exercise of others. So therefore, guys, nag-foreclose naman, regardless of the real estate mortgage, which is additional security to the debt, then the foreclosure upon the chattel mortgage barred recovery of the deficiency by foreclosing on the real estate mortgage. So take note here that the fact that the FIF company is seeking to collect the deficiency by going against the real estate mortgage is of no moment. R is only a guarantor. If she is compelled to pay the deficiency, she will in turn be entitled to recover what she has paid from the debtor vendee. So ultimately, it will still be the vendee who will be made to pay despite the earlier foreclosure of the chattel mortgage. Thus, the protection given by Article 1484 would be indirectly subverted and public policy overturned. So you cannot do indirectly what is prohibited directly, no? Suppose in the same problem, X company made an assignment of its right to FIF company with a right of recourse against the vendor assignor. Would there be a violation of the Recto law if the assignee will proceed against the assignor for the deficiency? So ang gukdo na ni FIF company ang katunang vendor, dili na si vendee. Can the Recto law be applied here in this situation? So no applicability of the Recto law. So pwede ra nga si assignee will go after the assignor. So what the law seeks to protect are only buyers by installment and not the sellers. Suppose that the mortgagor refuses to deliver the chattel subject of the mortgage upon failure to pay 2 or more installments. Or suppose that the mortgagor buyer conceals the chattel and the vendor mortgagee is forced to institute or file a suit for replevin in order to foreclose on the mortgage extrajudicially. Can there be a violation of the recto law if the vendor demands reimbursement of expenses and attorney's fees for filing that replevin suit? So answer is no. Okay? There's no barring effect. Dili barred ang recovery of expenses, cost of suit, attorney's fees. Because when the mortgagor / buyer plainly refuses to deliver the chattel or conceals it, then wala may choice. Makumpelled man jud si vendor, mortgagee, to recover, in order to recover the property, then mapugos jud siya file og replevin. So, there is no violation of the recto law. So recoverable expenses from the vendee will include all expenses properly incurred in effecting the seizure of the chattel and reasonable attorney's fees in prosecuting the action for replevin. Well, the basic philosophy of the recto law is that the underprivileged and underprivileged mortgagors must be afforded full protection against the rapacity of the mortgagees. Said law should not be construed as to deprive the mortgagee protection against perverse mortgagors. Okay, question. Under a lease of personal property with option to buy, it was agreed that failure of the lessee to pay 3 months rent would entitle the lessor to take back the property and the option to buy would be lost. So the lessee here failed to pay for 3 months. The lessor took back the property and then instituted an action to recover the rents corresponding to the 3 months. Can there be recovery, guys? No more recovery. It's barred by express provision of Article 1485. If the lessor already took back possession of the thing being leased, then it's as good as foreclosure. There's no more recovery of the unpaid rentals. Question. O, owner of a copying machine, leased it to L at a rental of 4,000 per month for a period of 1 year with option on the part of L to buy the copying machine at the end of 1 year for 80,000 pesos to be paid by applying the rentals so that L needs only to pay 32,000 pesos. So L failed to pay the rentals for the 4th, 5th, and 6th months. So that O terminated the lease and repossessed the copying machine. And then he sued L for the unpaid rental of 3 months. So is this suit to recover the unpaid rentals legally tenable? What do you think, guys? So it is barred under the recto law. Klaro kayo. Offeran good niya si L to purchase the copying machine. So how about in this financial lease agreements? I've already mentioned this case in an earlier slide. So let's take a look at this case. So PCI here leased equipment to Giraffe under a financial leasing agreement wherein PCI will acquire the equipment needed by the lessee in consideration for the payment of monthly rentals for 36 months, or until PCI, the lessor, will recover its acquisition cost with its profits. So Giraffe, the lessee, had to pay a guarantee deposit, and this guarantee deposit would be forfeited in favor of the lessor when the lease was pre-terminated. So take note, guys, the lessor here will finance the acquisition of an equipment needed by the lessee. Iya ang paliton ng equipment in consideration for the payment of rentals. Rentals ni lessee. And in case of pre-termination of the contract, there is a guarantee deposit to ensure that the acquisition cost of the lessor will be covered. So the lessee here failed to pay the monthly rentals. So the lessor PCI had to send a demand letter for settlement of the unpaid rentals and return of the equipment. So PCI, the lessor, seized the equipment and also kept the guarantee deposit. Plus, PCI sued the lessee, Giraffe X, for the collection of the unpaid rentals. So Giraffe X moved to dismiss the case and invoked the recto law. So Giraffe X argued, the lessee argued, that the financial lease was actually a lease with option to buy, and that the seizure of the equipment barred recovery of the unpaid rentals. So what's the ruling of the court in this case? So the court characterized the financial lease agreement as a lease with an option to purchase. Even the demand letter of the lessor stated that if the lessee would just pay the balance, then it could keep the equipment for its own. If not, then the leased equipment should be returned to the lessor. So there is clearly an option to purchase given to the lessee. So this is a circumvention daw of the recto law because the present case will reflect a situation wherein the financing company can withhold and conceal up to the last moment its intention to sell the property subject of the financial lease in order to circumvent the recto law. So even if the financial lease agreement does not contain a purchase option clause, it will not avoid its characterization as a lease with option to buy. So nangasaba si court ani nga case. So Supreme Court said, as noted in the case of Viuda de Jose versus Barueco, sellers desirous of making conditional sales of their goods but do not wish to openly make a bargain in that form for one reason or another have frequently resorted to the device of making contracts in the form of leases, either with options to the buyer to purchase for a small consideration at the end of the term, provided that the so-called rent has been duly paid, or with stipulations that if the rent throughout the term is paid, title shall thereupon vest in the lessee. It is obvious that such transactions are leases only in name. The so-called rent must necessarily be regarded as payment of the price in installments, since the due payment of the agreed amount results by the terms of the bargain in the transfer of title to the lessee. So, karaan na kayo siya nga device, guys. Okay, take note, in this case, kaning financial lease agreement, this kind of contract, there's a special law which governs governs these kinds of agreement. But the court still applied the civil code despite this Special Law Republic Act 8556. So in Republic Act 8556, a financial lease is defined as a mode of extending credit through a non-cancelable lease contract under which the lessor purchases or acquires at the instance of the lessee machinery, equipment, office machines, etc., and other movable or even immovable property in consideration of the periodic payment by the lessee of a fixed amount of money sufficient to amortize at least 70% of the purchase price or acquisition cost, including any incidental expenses and a margin of profit over an obligatory period of not less than 2 years. Okay, and during this period, the lessee has the right to hold and use the leased property, okay, but with no obligation or option on his part to purchase the leased property from the owner lessor at the end of the lease contract. So this kind of lease, guys, kaning financial lease, it will not escape the application of recto law. Right, so that concludes our lecture on chapter 10, remedies of parties in case there is a breach of a contract of sale of movable property. So our next lecture will be all about remedies when there is a breach of a contract of sale involving real properties or immovables.